The state agrees. If it's error, it's structural. Nobody disputes that. The state's position is, well, yeah, but he didn't plead until 4 days later when they told him his rights. But he didn't plead after that. And what the law says, what this court has said, what the rules say is that you plead after you know what you're waiving, not before.
Counsel,
yes.
Let me ask a question. When the judge corrected the missing sections of the colloquy under Criminal Rule 11, did he go soup to nuts again, or just the missing portions from the first, what was missing from the first colloquy?
No, he went through the whole, through the.
So he did A to Z once again, but merely did not ask your client, how does he plead?
That's correct. Yeah. Yes, Your Honor. That's correct. So the explanation, the only real explanation for what happened is that nobody was paying attention. And because everybody there, all these people knew what was supposed to be done. They'd done it before, they'd been through it. Nobody's paying attention. And the nobody's paying attention is sort of the continuing problem in this case. Think about, take a look at the sentencing opinion that we have here. And you see that the second sentence of the sentencing opinion is factually inaccurate. The second substantive sentence, it's factually inaccurate. It misstates the indictment.
Counsel, let me ask you this. Is there anything in the record that suggests how this inaccuracy was brought to the presiding judge's attention 4 days later?
He said he was looking at the transcript and noticed it.
It wasn't brought by the attention of either of the parties? Nobody.
The only person who noticed it apparently was the presiding judge, or possibly some other member of the panel, but he's the one who said it, on looking at the transcript of the plea 4 days later, 4 days prior. And go back to that plea for a moment, because what Criminal Rule 11C3 says is that when a plea is taken in an aggravated murder case with death specifications, and it's accepted, the trial court may, the panel, that is, the three-judge panel, may, in the interests of justice, dismiss the specifications and sentence accordingly. That's a Criminal Rule 11C3. That's been the law since before Lockett. It's been the law all along. Obviously the court didn't do it, but what counsel wouldn't ask under these circumstances? We're not talking about a defendant who's trying to get a death sentence. It's clear Mr. Brinkman has tried to get a life sentence. At the very end of this whole proceeding, he says, I may deserve death, but I'm asking for mercy. I'm asking for life. This is not somebody who's on a suicide mission. This is, and counsel, the only formal benefit of a guilty plea is that it offers an extra possibility of a life sentence. And counsel doesn't bother to ask for it. Neither of these attorneys thinks to ask for it. It may be denied. I'd submit that there is, by the standards of Strickland, which says a defendant need not even show counsel's deficient performance more likely than not altered the outcome of the case. It doesn't even have to be more likely than not. That's something more than a theoretical possibility, sure. But I'd submit that under these circumstances, that's not just ineffective, that's deficient performance coupled with adequate prejudice, at least under the standards that Strickland sets out. Again, it's a case of people, either they're ignorant of what Criminal Rule 11C3 offers, and they certainly shouldn't be if we've certified them and have the training, or they're just not thinking about it because nobody's paying attention, because everybody assumes where the outcome is going here. And you go back again, look at that sentencing opinion. where the panel first actually misstates the indictment. Then the panel says, and we're going to weigh here. We're going to see here that he is found guilty of the specification, acting both with prior calculation and design, and he's the principal offender. And that combination has special weight. And what we know is that combination can't exist under the law. Yes, he's charged as both, but he can only be either the principal offender or, as this court has said repeatedly, if you're principal offender and prior calculation and acting with prior calculation and design are separate things. Prior calculation is an aggravating circumstance only if it's not principal offender. Can't be both, except the panel weighs both. The panel says the brutality of the crime outweighs, that makes the confession worthless. But the brutality of the crime is the nature and circumstances of the offense. And the nature and circumstances of the offense can't be weighed, are not to be weighed on the side of aggravation, not to be weighed against the confession. They may have no weight. None of this may have any weight. That's up to the panel to decide. But what they can't do is weigh the nature and circumstances of the offense against mitigation, which is exactly what they do. They say that when the police came to find him, and when they got to where he was, they confront him. They're trying to arrest him. He's in a window in a house. He's got a gun up against his head. He has apparently, he suffers from type 1 diabetes. There's no question about that. The record is absolutely clear. He has gone and done things to make that worse. He's suicidal. The panel says, oh, he used he made an effort to throw himself into a diabetic coma. And he used that and faced the possibility of death. He used that, and I'm quoting the panel opinion here, to his advantage. That's his advantage? What we have here is, and you can detail it throughout. You can look at the photos, the autopsy photos. The state introduced, there are 3 victims. The state introduces a few photos, 15, 20, it varies for each of the victims, but a small number, a comparatively small number of photographs, autopsy photographs from each of the victims' autopsies, and then submits a disc with 100 more photographs that the pathologist who did the autopsy says, oh yeah, I took all these pictures, and submits that as the rest of these photos in evidence. What do they show? Well, it's not clear, but they're from the autopsy, except they're not all. The trial judge, the panel says this time there are objections, and over repeated objections, the panel says, yeah, they come in, we know enough to ignore them. They've all been authenticated. In fact, they haven't all been authenticated. Some of those photographs are not from the autopsy. Who knows where they came from? Nobody authenticated those. He said, but we won't, but really, it's okay to admit them because we know better than to pay attention to the ones we're not supposed to look at. Well, we know that the fact that the panel will ignore inadmissible evidence does not make the evidence admissible. And you get to the confession in this case. Mr. Brinkman speaks quite a lot There are hundreds of pages of confession to police in this case. And among the things that are in that confession, and the whole thing is introduced into evidence, a transcript of it and video of the confessions themselves. It's exhibits 500 and 501, I believe. And in that confession, he also talks about, while he's talking to the police, he talks about two killings that he committed the next day in Stark County. Those are separate. Everybody knew about them, but the state had agreed that they're not part of this case. The panel of judges had agreed it's not part of this case. Nobody moves to have that struck, to have the confessions redacted. Nobody objects to that. So they are there. And of course, that case is presently before this court, although it's further back, the state, I believe, just filed its brief in that case. It's all, everywhere you look in this case, what you find is people are not paying attention to the process. Why? I'd submit it's because everybody kind of assumed, oh, well, you know what? When the deal didn't work out, it was pretty clear. He's going to get a death sentence. We'll just go through the motions here and get there. And that's not what we do. If we do that in a case like this, if we do that in a death penalty case, what are we doing in lesser cases? What are we doing in the ordinary case? And what message are we sending to the public, to the judiciary, to the lawyers in this state that, you know, it doesn't matter. We don't care. Close enough for government work is close enough for our criminal justice system. It's close enough for our death penalty system. And we know that's not right. We know that's not right. That's why we have the special protections that we build into this system, to make sure that these cases are done properly. And when they're not, when you have a case like this where nobody's, frankly, and it really is, I keep coming back to it, it's the only explanation, nobody's paying attention. Everybody just kind of figures we'll go through the motions here and poor Mr. Brinkman will get sentenced to death. And well, what do you expect? That's not who we are. At least I hope that's not who we are.
Counsel, I wouldn't be the first justice to observe this, but a cynical view would say that your client's trial counsel sat on their hands during the process. What would you say to that?
Well, I certainly hope that's not true. You have, if they are intentionally sandbagging the case, then what they're doing is inexcusable. We demand competence from them. If they are intentionally, first of all, if they're intentionally sandbagging the case, they should be censured. They should be brought up on charges. If they're for ethical violations, because that's not what they're allowed to do, and we have no basis to think that. You know, these things happen. I mean, what's striking, and we've seen capital case. You review all the capital cases, actually, and you see over and over again that somebody misses something. I mean, non-capital cases too. I mean, and what do we raise all the time? Defense counsel is pointing to ineffective assistance of counsel here and ineffective assistance, and you know, most of the time, and I confess I'm probably guilty of this too, most of the time when we claim ineffective assistance of counsel, you know, we say it because it's what there is to say. It's what there is to argue. Once in a while, there really is ineffective assistance of counsel. And I will not accuse lawyers without hard evidence of intentionally committing ineffective assistance. And that's unacceptable, certainly. But if they did, even if they did in this case, then you censure the lawyers, but you don't blame the defendant. You don't kill the defendant because his lawyers committed misconduct. You don't kill the defendant because his lawyers are unethical, if they are. And you don't kill the defendant because it's not just his lawyers. It's the three-judge panel too. And they certainly weren't sandbagging the case. I mean, this is... From the moment of the plea, which is structural error, the truth is he should get a new trial just because of that. That's what your precedent says. That's what the law says. But from then on, it just all goes south. And when it all goes south like that, even if you somehow don't find the plea fully defective, then the death sentence itself is, the panel's opinion is so flawed, so filled with misconduct, with error, that it doesn't deserve the respect to even put this case before you for your independent reweighing of the nature of the aggravating circumstances against the mitigating factors. It shouldn't be here at all. This case should not be here now. And what it should be is returned to the trial court for a new sentencing proceeding. And if we have no further questions, I'll reserve the rest of my time. Thank you.
Thank you. Mr. Pateo?
Good morning, Chief Justice O'Connor. May it please the court. My name is Brandon Pateo. I'm with the Cuyahoga County Prosecutor's Office. I'm here on behalf of Appellee State of Ohio. I would agree with Mr. Gamso that death is different. I would, of course, disagree, as I did in my briefing, as to each of his propositions of law. I'd like to begin by addressing the plea, which is brought up in his second proposition of law. I submit to this court that death is different with regard to how a guilty plea can be conducted in a capital case. It is not merely a colloquy, as it is in so many felony cases. It is a procedure, a process that a three-judge panel must go through, that a defendant wishing to plead guilty to capital offenses must go through, pursuant to 294506. The trial court in this case, the three-judge panel, followed that procedure. The arguments put forward by Brinkman are that he needed to know everything at the beginning. He needed to, before anything else happens in this process, hear all of his constitutional rights, and otherwise the rest of that proceeding, anything he says after, any further record made is irrelevant. And that's not the case. That's not what this court said in Venny. That's not what this court said in Miller. This court is looking at a record that indicates, and there is no dispute, that prior to any findings made by the court, prior to the court ultimately accepting and rendering verdicts as to each of the counts of the indictment, Mr. Brinkman was fully advised of each of his constitutional rights. Mr. Brinkman affirmed that he knew what he was pleading to, that he wanted to plead to those offenses. That's the record before this court, and that is strict compliance. This procedure cannot be complete upon only a colloquy. Three-judge panel can't simply go over an initial colloquy and enter any findings. It can't actually accept the pleas at that point. First, it has to go through a process, and during that process, the state has to put on evidence and prove beyond a reasonable doubt what it has said in the indictment. The state, after that initial colloquy, put on witnesses, which were subject to confrontation by George Brinkman's attorneys. They were able to cross-examine any witness that they chose over those 4 days. prior to the court, and it's clear by the record that the court treated this as a protracted plea hearing. It had elements of a trial, but of course this was a plea. Of course, 294506 allows for a guilty or a capital defendant who wishes to plead guilty to plead guilty. It's not the same as a trial, but it has trial elements. During the course of this process, the state is putting on evidence. That evidence, those witnesses, are subject to cross-examination, confrontation. The trial court, the three-judge panel, did not accept the pleas until after all of that evidence was submitted, until after it had complied with 2945.
That's not what the court said, right? The court said it accepted the plea.
The court does initially, I believe it transcript at 157 or 156 say that it accepted the plea. But after that point, the state argues and requests, after the court has done what it is required to do by statute, has gone through and taken the necessary statutory steps that would allow for any findings upon a plea, that would allow for any sentence upon those pleas. The state asked the court to accept those pleas. And at that point, there is no dispute. Strict compliance has been met. At that point, the court has gone over with George Brinkman, and this is at 642 to 645 in the record, each of his constitutional rights, has made certain, has left no doubt for the three-judge panel, for any of the attorneys present, and for any reviewing court, that George Brinkman knowingly, willingly, and voluntarily was entering those pleas. And after that point, when the court rendered its findings at 674 to 678, the court explicitly said it was accepting the guilty plea as to each of those counts. That is where the acceptance happens.
Mr. Vitale, when I'm looking for that missing one of those 5 elements from 11, Criminal Rule 11, the actual language is to confront your adverse witnesses. And when I look at the supposed correction of the colloquy 4 days after accepting the plea, the most I can see is that Judge Corrigan says, and your attorneys would have the opportunity to confront and cross-examine each and every witness the state would bring forward. But it really, I mean, is that enough to be strictly, I mean, aside from the timing issue, is that enough?
Yes, I believe that's enough. And pursuant to this court's holding in Miller, that would allow the defendant in this circumstance to make a voluntary and intelligent decision whether to plead guilty, knowing that those rights would not be exercisable, and that those are the rights to confront any witness.
But the rule doesn't say, but the rule doesn't say your attorneys. The rule says you. It's the defendant. That's not mentioned anywhere.
Respectfully, Your Honor, I do believe that satisfies the rule. I think that a criminal defendant, certainly one represented by 2 attorneys at all stages in this process, would understand that to mean that he has the right. His attorneys are his representatives, and I believe that it is reasonably intelligible pursuant to this. But
when a defendant's kicked out of the courtroom for bad behavior, it's a real appealable issue whether or not the defendant actually had the right to be there, because it's the defendant's right to confront his or her adverse witnesses, not the defendant's right to have their attorneys do it. And if we're talking about strict compliance, whether or not you can get over the threshold of the timing issue, I think you still have a problem here with the language. I don't think the judge went far enough with the language.
Respectfully, Your Honor, I disagree. I do think that language is sufficient and would be intelligible to a criminal defendant. I certainly think it was understood by Mr. Brinkman and allowed for his pleas to be knowing, willingly, and voluntarily entered. I would like to address the reference to this being a timing issue. Again, the arguments put forward by Mr. Brinkman in his brief and in his reply brief suggest a reading of the rule that I don't think is accurate and does not support it with any case law, which says at the beginning of a plea hearing, at the beginning of a process, all of the rights must be put on the record. strict compliance requires that prior to the court accepting the pleas, the defendant must demonstrate to the court, and the court must be satisfied that a criminal defendant has knowingly, willingly, and voluntarily entered these pleas.
Counsel, how many times did Mr. Brinkman plead guilty?
He pled guilty once, Your Honor.
And that was after the first colloquy?
Yes, Your Honor.
And after the correction was made, was he asked again, how do you plead in light of this additional information that the court has put before him?
He was not asked in those words, Your Honor.
Well, he wasn't asked in any words, was he?
Well, he was asked whether he wished to waive all of those rights, and he affirmed it. He affirmed as to each right.
All right, but that's not the same as then entering a guilty plea after full information is laid out for him.
It's not the same in that it's not the same literal words. I submit to this court that it allows for the same strict compliance, that it allows for clarity that the court understood, that Mr. Brinkman understood. Mr. Brinkman was given the opportunity to say prior to the court accepting these pleas, prior to the court saying, we have determined that you are guilty, we can make these findings at this point in the procedure.
Well, accepting a plea and making findings are two different things.
That's correct, Your Honor, but the point of the plea, the effect of a plea is that a court can make findings. And in an ordinary criminal case, and both myself and appellant agree, this is not an ordinary case, but in an ordinary case, a plea colloquy is sufficient. You go through a plea colloquy and that's it. That's the plea hearing. Then the court, and the courts say this, the courts must tell defendants this, the hearing, as soon as I accept your guilty pleas, I can move on to making findings of guilt. I can move on. I won't usually, but I can move directly to sentencing.
But in this case, we have the court accepting the plea before all the rights were given, correct?
The court says it accepts the plea at that point. But I would put forward to this court that what the court actually does is accept the pleas in a meaningful way at the end of the hearing.
Meaningful to who? The court or to the defendant?
To both.
So they accepted it twice. The court voiced acceptance of his plea twice. Once after the first colloquy, which was incomplete, and then at the conclusion of the state's case to, put forth the circumstances of the crimes.
Correct.
So the court, excuse me, Mr. Pateo, after the court asked him the questions, several questions, including the language I read to you earlier on the second time, the court said, is that satisfactory to everyone? And everyone said, yes, Your Honor. But at no time did he say, I accept your plea now.
Or understanding your rights, do you still plead guilty?
Correct.
Well, I do believe that so to answer the first question, as I understood it, the court does accept his pleas at the transcript at 674 to 678. At the time the court is making its findings, the court says, I accept your plea of guilty to count 1 and to the accompanying specifications. I accept your plea to count.
Counsel, that plea was after the first colloquy. It wasn't subsequent to the additional constitutional information that was a constitutional right information that was afforded Mr. Brinkman.
That plea was, Your Honor, to the entire process of the guilty plea. The guilty plea is not complete in a capital case upon just the colloquy at the beginning. If the court goes through that colloquy and stops there, there is no acceptance. There is no ability for the court to make findings. There is no ability for the court to render judgment.
Yeah, I understand. I understand that the state has more to do, post colloquy and plea in order for the court to do what you just mentioned, except. But I still am troubled by the fact that he only agreed to plea once, and that was after the incomplete colloquy.
I would direct the court to the transcript at 642, where when the trial court engages with Mr. Brinkman for the second time regarding his rights, he is assuring that Mr. Brinkman understood all of the rights he was giving up with respect to the trial, with respect to the right to confrontation, with the right to have his guilt proven beyond a reasonable doubt. And I would again remind this court of its decision in Miller, where it said that the court must be satisfied such that, in that case, Miller could make a voluntary and intelligent decision whether to plead guilty, knowing those rights would not be exercisable if he did. The two rights in question here, the right to confrontation and the right to have your guilt proven beyond a reasonable doubt by the state, those rights are exercised in the intervening time. Mr. Brinkman, through his attorneys, is given the opportunity to confront each of the state's witnesses during those 4 days. Mr. Brinkman has the state, pursuant to statute 294506, prove his guilt beyond a reasonable doubt, such that the three-judge panel can make a decision. These are extra protections that were afforded to Mr. Brinkman. They were properly afforded.
Mr. Mateo, the court never even said the second time it tried to get the colloquy correct beyond a reasonable doubt. It just said, and you are presumed innocent until, in fact, the state proves you otherwise. And they never, the court never said beyond a reasonable doubt. Not in the first instance or the second instance.
At 643, do you also understand you have the right to have the state, through its prosecuting attorney, prove your guilt by evidence beyond a reasonable doubt?
Okay.
And I'm reading directly from the transcript.
All right, I'm corrected. Thank you. Was that in the first colloquy or the second?
That's in the second colloquy. The court does, prior to going through the rest of the process mandated by 294506, inform Mr. Brinkman, I believe at 158 in the transcript, that the court will not be entering any findings at that time, that the state will be proving his guilt beyond a reasonable doubt. The state will be entering that evidence.
And I do see where I missed the, thank you. I see where I missed the language.
Certainly, Your Honor. If there are no further questions regarding this proposition of law, I would move on. I believe the next proposition of law addressed by Mr. Gamzo was regarding the ineffective assistance claim in proposition of law number 8. Regarding those arguments put forward by Mr. Gambo, I submit to this court, as I did in the brief, there is absolutely no showing of prejudice to Mr. Brinkman. I think the largest issue put forward by Mr. Gamzo is under Criminal Rule 11C3, that his counsel did not move for dismissal in the interest of justice. I submit to this court that there is nothing in the record to suggest that that argument would have been fruitful. There is nothing in the record to suggest that his counsel determined there was a better chance of succeeding under that. There was a better chance of this being dismissed in the interest of justice. There was simply nothing in this record to suggest that three-judge panel would decide the interest of justice required that the capital specifications be removed at that point. It's clear from the record that his counsel did make every attempt to argue for life based on mitigation. They put forward all manner of mitigation that may have allowed the panel to determine if mitigating factors outweighed the aggravating circumstance. They weren't successful, but their lack of success there does not dictate that that was not the best approach for Mr. Brinkman. And that's where they focused their efforts. With regard to proposition of law number 3, this case and the cited issue with the aggravating circumstance is quite distinct from what occurred in Penix. Penix was the case in which this court first recognized an issue with a jury instruction in that case, where the aggravating circumstance was in fact doubled. There should have been one aggravating circumstance considered. The jury should have been told, consider one aggravating circumstance, that is what is available, that is what is statutorily correct. And instead, the court took the disjunctive principal offender and committed with prior calculation and design, split that into two, and told the jury not only was it considering two, one of which was not statutory at all, was not listed under 292904A7, but was merely practically a recitation of aggravated murder, just that it was committed with prior calculation and design. And the court instructed the jury to give those extra weight, to consider especially that there were multiple aggravating circumstances. And again, there shouldn't have been. Again, in that case, there was no additional aggravating circumstance for the state to prove, for the jury to find. In this case, there were 3 aggravating circumstances available. There were 3 aggravating circumstances proven. The panel, it is incredibly clear, considered those 3 aggravating circumstances. It's also clear the panel did not give extra weight. I believe Mr. Gamzo said there was a finding of a combination of special weight. Nothing in their opinion says they gave special weight to the finding of the conjunctive. This court, in its independent reweighing of that sentencing, of the weighing of the aggravating circumstances against the mitigating factors, all it needs to do to make this appropriately statutory is strike the conjunctive that was added. Prior calculation and design is not relevant because George Brinkman was the principal offender in each of these aggravated murders. Again, there are multiple differences between the issue that caused reversal in Penix and what occurred here. And in Dixon and in several other cases, this court has identified that its reweighing process can cure that issue. But I want to be very explicit. This was not non-statutory in that the court shouldn't have considered the aggravating circumstances. The court properly considered the course of conduct, that each aggravated murder was committed in the course of conduct of killing 2 or more people, in this case, Suzanne Taylor, Kylie Pfeiffer, and Taylor Pfeiffer, but also the 2 felony murder aggravating circumstances. The only issue in the way they were recited was that the conjunctive prior calculation and design was included. With regard to the arguments related to the sentencing opinion, in proposition of law 4, I believe it was 4, the panel did not improperly consider or weigh the aggravating circumstances against mitigating factors at the wrong point in its opinion. It evaluated the weight to be given to the mitigating factors. And the opinion, I believe, speaks for itself, but the arguments made regarding, I think, especially the mitigating nature of the confession, the panel considered the circumstances of that confession. They considered when was that confession made? What was the veracity of that confession? How honest was Mr. Brinkman? What details did he provide? And the panel noted that that confession left the victim's family, left the police with unanswered questions. Questions about where his bloody clothes went. Questions about where the murder weapons went. Questions about why he described the murder weapon just as he had described knives, and as the police knew, there were knives purchased at Walmart just before the murders, but so that those weren't the murder weapons. He claimed to leave money for the girls. He claimed that that was part of his purpose for going to the home. $800 each for Taylor and Kylie. Nothing was left at the home. Nothing was found by police through multiple sweeps of the house. So the court properly weighed that mitigation, properly determined what weight should be applied to it, and there is no error there. With regard to the court's weighing of his medical issues, the panel was not, by any law cited by Mr. Brinkman, required to put particular weight towards those medical issues. The arguments that Mr. Brinkman's diabetic issues should have been given more weight, apparently, than the panel ascribed to them. And the panel shouldn't have considered that they were used to delay his apprehension, that by putting himself into a diabetic state, he required hospitalization. I submit to the panel, that's a proper weighing, that's a proper determination of the weight to be given to that mitigation. He held the police at bay after failing on June 11th to go to North Royalton. He was requested, he had an appointment to meet with the detectives. By not showing up, he required a SWAT team to go and find him. And that wasn't enough. He held the SWAT team at bay for about 8 hours with a firearm, threatening to take his life. During that time, he put himself into a diabetic state so that it wasn't just the 8-hour standoff where he used a firearm to keep himself from being apprehended for that much longer. He had to go to the hospital directly from the house so that he could be stabilized. So again, I submit that that's a proper weighing. With regard to the proposition related to the autopsy photos, proposition of law number 7, there is nothing to indicate that the panel considered improperly any of those autopsy photos. There is nothing to suggest that the panel in the record or in the decision was inflamed by those autopsy photos. And that is what this court should be considering pursuant to Brewer. This court presumes that the panel will properly consider the evidence.
Mr. Potato, when the panel ruled on the admissibility of the state's exhibits, it included everything on those discs, right?
That's correct.
And so that's, and you're saying nothing in those exhibits was prejudicial?
Correct.
Okay, so that's where you and your colleague differ then.
Yes, and additionally, Mr. Gamsa pointed out that not all of the photos are actually of the autopsy examination. It's clear on review of those photos that certain of them depict the victims where they laid prior to being moved, as autopsy photos generally do when the decedents are not rushed to the hospital. They were dead upon the arrival of investigators, so there were photographs taken of them at the home and then also during the autopsy. So the additional photos referenced, it's quite apparent, are of the victims just prior to the autopsy.
So, and so the authentication, you're saying that the authentication of the employee of the coroner is enough, even though they were taken probably by a police officer at the home?
I think the authentication is enough. And I also would cite to this court, State v. Issa, State v. White, State v. Post. There are presumptions this court makes. The trial court will not improperly review evidence. The court will not be improperly prejudiced by evidence, that it will review only appropriate evidence. And pursuant to State v. Brewer, there's nothing to suggest, there was no indication that the 3-judge panel was inflamed by the presentation of autopsy photographs. Similarly,
so there's no, even though I think everyone pretty much understood that the coroner's employee really couldn't say that he or she took the photos, but they just came to him, that there's no error in evidentiary admissibility there, correct?
I would submit to the court that if there is any error in the admissibility, what this court looks at in reviewing is whether that error caused any prejudice to the panel, or most specifically, whether the panel was inflamed. With regard to the first phase, this was a guilty plea. So Ketterer says, this court has said in Ketterer, he can't be prejudiced because he is willingly pleading guilty to these homicides. And with regard to the consideration of the guilt phase, there's nothing to suggest. When you go through the sentencing opinion, the photographs, I don't believe, are even referenced. There's no suggestion that they came into the panel's consideration. Any of the photographs, and certainly not the photographs which Helen has put at issue.
Thank you.
Pending any other further questions, I would ask the court to affirm the convictions and sentences.
Thank you. Mr. Gamso, you've got about 7.5 minutes.
Thank you, Your Honor. Yeah, kind of going backwards here, there is a difference between error and harmful error. And the court's not supposed to commit error, regardless of whether it's harmful. The court's not supposed to commit error. And when it does, when in a case, in a death penalty case, when the court commits error, that's something we want to pay attention to. When things go south, and they did here, you know, I mean, Mr. Patillo correctly says that the plea proceeding requires that hearing. That 11C3, Criminal Rule 11C3 says, yes, after that there is going to be this proceeding where the 3-judge panel is going to hear evidence and render a decision. When that happens, that's part of the proceeding, sure, but it's not part of the plea. The plea itself happened right up front. And the plea, and here's what the court actually said. On page 157, it says, the record should reflect that the court does accept the pleas, finds that they are knowing and voluntary, with a full understanding of his rights uttered or entered at this point. If the record is unclear, it says further down on the same page, on page 157 of the transcript, if the record is unclear, we've accepted the plea. There is simply no ambiguity about whether the court accepted the plea at the time it did not run through all the rights. And the fact that later on, 4 days later, it runs through the rights and Mr. Brinkman does not plead again. So we're going to assume that that original plea, when he pled guilty, was knowing, intelligent, and voluntary because 4 days later we told him what he was waiving. We tell him, we demand that he know the rights he's giving up before he enters the plea, because that's how we can tell that it's knowing, intelligent, and voluntary. Not that he enters the plea and then we tell him, oh, by the way, you gave those things up. You know that? And by the way, do you plead again? Do you still want to plead? Oh, no, we don't do that. We didn't do that. Mr. Patillo says that there is nothing that tells us that the interests of justice would have led the court to have dismissed the death specifications. And once again, the question is not, according to Strickland, whether they probably would have. It does not even, a defendant need not show, page 693 of Strickland, a defendant need not show that counsel's deficient performance more likely than not altered the outcome in this case. So what would be the interest of justice here in dismissing the specifications? I would submit that they include genuine remorse, regardless of whether his confession covered every detail, regardless, yes, he didn't tell them where he disposed of the knife. He didn't tell them where his dirty clothes were, or his bloody clothes. Those are hardly he did say, yes, I killed those women. I killed those people I cared deeply about, which is the other part of this. The important thing that he confessed is that he's guilty. He admitted that. He put this out. He said, I don't want to put the family through this anymore. There's genuine remorse here. He's willing to plead. He actually does plead guilty. He has, you look at his history, And the man is 45 years old at the time of these crimes. He has a criminal history. That's true. None of it's violent. And he has not had any interaction with law enforcement, it appears, since he got out of jail or out of prison in 2001. This is 2017. He's had 16 years of no interaction with the criminal justice system. That's worth something. This is aberrant behavior. These are people he cared deeply about. There's no question about that. Nobody disputes that. His physical condition is seriously problematic. He is more than willing to accept, really, to accept a sentence that will keep him imprisoned for the rest of his life. The sentence he's asking for is death in prison. The sentence that the state has pursued and that everybody ended up with is death in prison by execution. Either way, he's never going to get out. And I'd submit that under those circumstances, it is at least not frivolous. It is not, well, yeah, theoretically anything can happen. Why not ask for it? There is at least a reasonable probability, as Strickland defines that term, that a request to dismiss the death specifications in the interest of justice might have been granted. And not to ask for it, when it's the single thing that he's trying to get, which is a life sentence, and the single thing that a guilty plea technically entitles him to that he would not be entitled to if he did not plead guilty, is that possibility. We heard that the state, and I don't fully understand what Mr. Patillo was saying, but on the question of whether the court improperly weighed as aggravation both the nature and circumstances of the offense and that it was committed with prior calculation and design. This court has made clear it's one or the other. It's one or the other. Prior calculation and design only applies if you're not the principal offender. And here's what the sentencing memorandum says at pages 4 to 5. RC 2929.04A7 requires the state to prove either that Brinkman was the principal offender or that he committed the aggravated murder with prior calculation and design. That's correct. Has to do one or the other. In this case, both are true. Brinkman was the sole and principal offender in each aggravated murder, and he committed all 3 aggravated murders with prior calculation and design. Those aggravating circumstances, that's a plural, those aggravating circumstances are also entitled to great weight. That's not the law. That's error. It is just another instance in this case of a failure throughout to get it right, to care enough, to give the case the attention it needs, it deserves, to give Mr. Brinkman the attention he deserves, to give our system, our understanding of what the public is entitled to, frankly, the attention it deserves, to be sure that we actually have a sentence that we care about and that we can feel comfortable with. And when we don't have that, when we don't even do that in a death penalty case, then what do we do in the ordinary case? What's the lesson we're sending? What are we telling people? What are we allowing to happen? I'd submit that from the get-go, this case went wrong. Structural error happened at the beginning. Mr. Brinkman is entitled to a new trial. At the very least, he is entitled to a new sentencing proceeding. This court's independent reweighing cannot cure the wealth of error in this case. And absent further questions, I ask you to reverse. Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision. All right, our next case is 2020-306, the Motorist Mutual Insurance Company versus Aronix Incorporated et al. And Mercy Comer et al. For the appellant, Mr. Evans.
Thank you, Your Honor. To begin with, I would like to reserve 5 minutes for rebuttal if necessary. My name is Merle Evans. I represent the appellant, Motorist Mutual Insurance Company. This appeal involves a coverage dispute between Motorist Mutual, its insured, Aronix Inc., and the claimant, which is Owens Brockway Glass Containers. Aronix is in the business of processing tube scale, and it sells it to various customers, including Owens Brockway in this case. The sale of the tube scale to Owens Brockway was pursuant to very detailed purchase orders that were, set forth the specifications, the terms, and the conditions of the sale. This was a transaction between two commercial entities. Owens Brockway then utilized the tube scale in the manufacture of glass. It was mixed with other component ingredient parts and to make glass containers. After the glass containers were manufactured, Owens Brockway discovered that there were large stones that had been provided in the tube scale that had been provided by Aronix. And they determined that the existence of the stones led these glass containers more prone to breakage, so they discarded everything. Owens Brockway then asserted claims against Aronix. Aronix at the time was insured by Motorist Mutual under a business policy. There were two coverage forms in play, which would be the CGL coverage form and the umbrella coverage form. Motorist Mutual had me file a declaratory judgment action, which was filed in Wood County. The case was brief. There were stipulated facts, and the trial court ruled in favor of motorists under both coverage forms. In essence, the trial court ruled that providing contaminated tube scale is not accidental and does not constitute an occurrence as defined in the CGL. The trial court also ruled that the damages do not constitute property damage as defined in the CGL, and that certain business risk exclusions also applied. As to the umbrella, the trial court ruled that the claimed damages do not constitute property damage as defined in the umbrella, and that certain business risk exclusions applied. The trial court's ruling was appealed to the 6th District Court of Appeals. The 6th District affirmed the lack of coverage under the CGL coverage form, but then reversed and determined that coverage was available under the umbrella. So the issue here today is, and what we have appealed is the ruling under the umbrella coverage form. We believe that the Court of Appeals committed multiple errors in its coverage analysis. And, the issues have been well briefed, but I did want to hit some of the highlights. First of all, the Court of Appeals failed to determine if there was an initial grant of coverage under the insuring agreement in the CGL. The Court of Appeals simply said they decided not to look at the issue of whether or not the property damages were caused by an occurrence. The Court of Appeals decided to skip over that analysis and just, they say in the appellate opinion that we're simply going to assume that an occurrence happened and that it caused property damages as defined in the CGL. The court then just jumped to the exclusions in the policy and determined that a contractual liability exclusion applied. And motorist believes that the failure to, this was an improper coverage analysis. The courts always start with, was there an initial grant of coverage first? And then after they determine that there is coverage based on the insuring language or the insuring agreement, then they look at the exclusions. Here, the court just says, we're going to assume all that, and they jumped right to the exclusions. Now, why is that important? Well, we believe that the court would have made a certain determination in favor of motorists under the CGL, and that would have then applied to the umbrella. The next issue with respect to the appellate court's ruling was its failure to consider the rationale and the holdings of the Ohio Supreme Court and the Custom Agra case and the subsequent case of Ohio Northern University. In Custom Agra, the Ohio Supreme Court had ruled that claims of defective workmanship are not claims for property damage caused by an occurrence under a CGL. The court recognized that CGL policies are not intended to protect against every risk of operating a business. In particular, these CGL policies are not intended to ensure business risks that are normal, frequent, or predictable consequences of doing business and which business management can and should control or manage. The Ohio Supreme Court made it very clear in Custom Agra that CGL policies are intended to ensure the risks of an insured causing damage to other persons or property, and that the policies are not intended to ensure the risk of insured causing damage to its own work. The court also pointed out that the CGL policies are not performance bonds, and that the fortuity principle is central to the notion of what constitutes insurance. These holdings and legal principles set forth in the Custom Agra opinion, we believe, are essential to any coverage analysis, including an analysis under an umbrella policy. Yet the Court of Appeals failed to consider or even address any of those issues. Instead, what the Court of Appeals did was it attempted to distinguish the umbrella policy from CGL policies. It pointed out that in its opinion, the coverage provided by the umbrella was more expansive than CGL. So as a result, the Court of Appeals decided, well, we're just not going to apply these basic insurance principles set forth in Custom Agra. And we think that was error. In fact, there was a case.
Did you argue below that that's definite, that fortuitous concept applied to the umbrella policy?
Did we argue that?
Yes.
I believe we did, Your Honor. There have been so many briefs filed in this matter. We definitely, in our briefs, I know we argued Custom Agra and what Custom Agra stood for, what these policies are intended to do. And anyways, the Ohio Supreme Court previously, in the Anders opinion, had said that the same analysis was applied to a homeowner's policy as applies to an umbrella endorsement. And so, in other words, the Ohio Supreme Court in the Anders case has said the analysis is the same. And here we believe that the Court of Appeals simply ignored some of these insurance concepts. The primary argument that we made in the court below, and in fact in this case, is whether or not damage to other property occurred. And here the Court of Appeals simply says, well, it doesn't really matter. We determine this to be property damage. Motorists had made the argument that under these liability policies, including umbrella policies, that there has to be damage not to the insured's own product, but to other property or to other persons. The integrated system rule has been applied, under Ohio law, under the economic loss rule. And there was an excellent opinion from the insurance industry standpoint, the Wisconsin Pharmacal case versus Nebraska Culture, and it was issued by the Wisconsin Supreme Court. And we believe that case is directly on point. And basically what the Wisconsin Supreme Court held was that when a component ingredient is incorporated into a final product that makes the final product useless or less useful, there is no damage to other property and no property damage for purposes of insurance liability coverage. And the Wisconsin Supreme Court relied heavily on the rationale behind the integrated system rule as utilized in the economic loss concept. The economic loss rule is...
Counsel, is that case really influential to us? I mean, it was a narrowly decided case with not even the entire court, if I recall correctly. Wasn't it a 3-2 decision on a 7-person court?
Your Honor, it is a law. I mean, it was issued by the Wisconsin Supreme Court.
It was, without question, and it was a majority ruling of the court, but it was close. It wasn't. I should say it is such reliable authority for us. I mean, obviously not binding, but influential.
Well, Your Honor, we do believe that it is very persuasive authority. The facts are almost directly on point to the facts we have here. And also the the insurance concepts and the legal principles that they addressed in the Wisconsin Farm Roll case also exists in Ohio.
Well, isn't it, I mean, these are two business entities. Shouldn't they be able to, incorporate in their contract, whether they want an integrated product or system rule in the language of the insurance agreement?
Your Honor, yes, between the two entities, Ironics and their customer, there was an agreement that set forth a lot of different things. We believe that this is not, based on the court's ruling and custom act.
Well, but I mean, for insurance contract, when we're talking about commercial liability insurance contract.
Yeah. Oh, I'm sorry. Yes, I mean, insurance companies can put anything into the policy that they want to, and if the insured agrees to it, that's that. Here, and I know there's been some, criticisms of the language in the motorist policy, but these are standard policies with standard language, and a lot of these same issues. In all the cases mentioned in the brief, the courts did not say, well, the insurance company should have said this or that. They looked at the language that existed. They applied legal principles and insurance law. With that, I see I only have about 3 minutes left. I would like to reserve that for rebuttal. So thank you very much.
Thank you, Mr. Evans. For the appellees, is Mr. Dunn first? You're muted, sir.
Excuse me. My name is Ted Dunn. I have the privilege of representing Ironics, Inc., who is the insured under the motorist policies at issue in this case. Business risks are covered by general liability policies when they involve property damage due to an occurrence, and the business risk exclusions in the policy do not apply to bar coverage. When reviewing a CGL policy, prospective policyholders tend to pay careful attention to the business risk exclusions, because it's the heart for the policyholder to determine what business risks will or will not be covered. This appeal is important to Ohio insureds in general, and Ohio component manufacturers and suppliers in particular, for several reasons. Prospective policyholders need to be able to rely on the policy language to make informed purchasing decisions. Policyholders also need to expect that their policies will perform as issued and written. And finally, Ohio courts should not be called upon post-loss to defeat coverage by rewriting policies to limit coverage or expand exclusions based on an insurer's undisclosed underwriting intent. Motorist claims in this case that the damage to Owens bottles is not damage to other property under the policy. This proposition is not found in the definition of property damage. The concept of damage to other property is addressed in the your product exclusion. But the your product exclusion is limited to Ironic's product, its tube scale. It does not incorporate the Wisconsin Pharmacol integrated system rule, and the your product exclusion is not reasonably interpreted to exclude Owens' damaged bottles. The impaired property exclusion is the one and only policy provision which expressly addresses the damage to another's property due to the incorporation of an insured's component. This exclusion does not eliminate coverage anytime an insured's component damages another's integrated product. The definition of impaired property, by exception, permits coverage when the insured's component causes irreparable physical injury to another's integrated product, which is exactly the situation with the damage to Owens' bottles caused by Ironic's defective tube scale in this case. This exclusion demonstrates that motorists considered this business risk and chose to exclude coverage only if the physical injury to Owens' bottles could be remedied by repair or replacement of Ironic's defective tube scale. In other words, by Ironic's performance of its contract with Owens. This is a standard exclusion that commercial liability insurers have been underwriting for years. There's no evidence whatsoever to support the suggestion that commercial liability insurers are unable to underwrite the scope of coverage afforded to component manufacturers or suppliers for irreparable injury to another's integrated product. This court should not adopt the Wisconsin Pharmacol integrated systems rule in this case for several reasons. One, motorists' argument regarding damage to other property using the integrated systems rule is nowhere expressed in the policy. It's not found in the definition of property damage. It's not found in the your product exclusion in the definition of your product. And it's not found in the impaired property exclusion in the definition of impaired property where the damage to the integrated product is irreparable. To impliedly expand the definition of your product to include other property or to impliedly expand the definition of impaired property by removing the exception for irreparable damage violates fundamental rules in Ohio for construing exclusions. Also, the foundation of the integrated systems rule is a doctrine of tort law designed to protect the integrity of contract. In Ohio, the integrated systems rule is not a rule of insurance coverage law. As a rule of insurance coverage law, the integrated systems rule would undermine the integrity of the insurance contract by defeating coverage despite the policy language. Confined to its proper purpose as a tort doctrine, the integrated systems rule does not defeat coverage because Ohio law does permit coverage for breach of contract claims and economic losses when the requisite property damage and occurrence are present. Also, in its definition of property damage, motorist provides coverage for economic losses as consequential damages when there is physical injury to or loss of use of tangible property. And the Wisconsin Pharmacol case was decided over a strong and persuasive dissent. The case is an outlier and no other jurisdiction has followed Wisconsin Pharmacol to my knowledge. Also, the Wisconsin Pharmacol integrated systems rule would eviscerate important insurance coverage for Ohio component manufacturers and suppliers for no valid policy reason. Also, the Wisconsin Pharmacol decision is highly distinguishable upon its facts. In Wisconsin Pharmacol, the Supreme Court considered the element of physical injury to tangible property under Wisconsin law and California law. This is because there were two suppliers in the supply chain for the incorrect LA ingredient, and they had two different policies under different state laws. Under Wisconsin law, the Supreme Court applied the physical alteration test to determine whether or not there was physical injury to tangible property. The court found there was no property damage under that definition because the incorrect LA agreement did not physically alter any other ingredient in the probiotic tablets. The use of an LA ingredient versus an LRA ingredient only caused the probiotic tablets to be mislabeled when they were shipped to retailers. The court said this is not a physical injury to tangible property case. This is a mislabeling case that doesn't fall under a CGL policy. Under California law, the court applied the hazardous condition test. One of the cases they looked at was Shade Foods. In the Shade's Food case, cereal was contaminated by wood splinters and almond that was integrated into the cereal. The court in that case found that because the wood splinters could not be removed from the cereal, and they prevented, and the injury presented a hazardous condition, that the physical injury to tangible property element was satisfied. The court looked at the facts in the Wisconsin Pharmacol case and said, we don't have a hazardous condition. We simply have a mislabeled product. So confined to its facts, Wisconsin Pharmacol stands for the proposition that to constitute physical injury to tangible property, the component either has to physically alter the integrated product, or it has to cause the integrated product to be hazardous for use. The property damage claim against Ironics in this case satisfies both of those tests. So it's not at all clear that Wisconsin would say that in this case, the facts of this case, that we don't have physical injury to tangible property. If the court does not adopt the Wisconsin Pharmacol integrated system rule, the public will not suffer. Willing insurers will continue to offer this integrated or impaired property coverage. Insurers that are unwilling to offer this coverage need only include a broadened business risk exclusion for your product or impaired property in their policies. On the other hand, if this court does adopt the Wisconsin Pharmacol integrated system rule, the liability insurance market for Ohio component manufacturers and suppliers would be unduly restricted. Willing insurers effectively would be precluded from insuring this business risk arising from an insured's component, causing irreparable damage to a customer's integrated product. There's simply, and turning to the doctrine of fortuity, which was addressed by the Court of Appeals, there's no basis to expand custom agri in Ohio Northern beyond the faulty construction work performance cases to bar coverage in a product defect case of this nature. Ironics did not perform or control any of the work on Owens glass bottles. The irreparable damage to Owens glass bottles was completely unexpected and unintended, and it could not be remedied by Ironics' performance of its contract through either repair or replacement of its defective tube scale. The notion that the doctrine of fortuity bars product defect claims because the risk of selling a contaminated product is a normal, frequent, and predictable business risk, which component manufacturers and suppliers are solely responsible for controlling, does not apply to the facts of this case, does not apply to the policy definition of occurrence, is overly broad, and is not supported by this court's decision in Custom Agri in Ohio Northern. In this case, Ironics obtained its raw tube scale from American Waste Management. American Waste Management encountered a problem. They had batches of tube scale that got contaminated with sediment at the steel plant. Ironics said, we cannot accept the tube scale in that form. You're going to have to undergo a process to remove the sediment. So American Waste Management sent the tube scale to a third-party screener. The third-party screener screened the tube scale, then called American Waste Management and said, we had a substantial amount of tube scale that spilled on the ground. What should we do? American Waste Management said, well, just rescreen it and go ahead and send it on to Ironics. This was unbeknownst to Ironics, and the unfortunate circumstance is that Foundry Steel Services also screened silica products. And so when they scooped up the tube scale that was on the ground, they incorporated these chrome stones in the tube scale that was sent to Ironics. This tube scale then was sold to Owens. Owens used it to mix its glass bottles. Once the tube scale was mixed with the glass bottles, the chrome stones didn't were not dissolved through the molten process. They remained intact in the glass bottles, which caused the glass bottles to lose their structural integrity, to be susceptible to damage and injury. Having determined that its glass bottles were irreparably damaged, Owens decided that they had no choice but to scrap the glass bottles. This case simply does not implicate the doctrine of fortuity or the incurrence requirement. Ohio law, when looking at occurrence, focuses on the consequences of the Insured's Act and not the act itself. In product liability, that focuses on the consequences of the insured's conduct in the form of property damage or personal injury following the product's manufacture and sale. To hold that the proper focus is on the intended act of manufacturing or selling the product would exclude much of the realm of negligent acts causing property damage or personal injury. And I would ask the court look at Professor Pryor's article, The Economic Loss Rule and Liability Insurance, pages 915 and 916. The fortuity element of occurrence is not violated here when the damage to Owens glass containers was unexpected or unintended from the standpoint of ironics, which is exactly what the policy definition of occurrence states. Occurrence means an accident, happening, or event which results in property damage neither expected nor intended from the standpoint of the insured. Whether the insured expected or intended focuses on the property damage. And this complies with standard Ohio law, which says that such as Physicians Insurance Company of Ohio and Swanson, which says that is the focus of this analysis.
Mr. Dunn,
Also,
isn't that also kind of how an umbrella policy works? And didn't the Court of Appeals analyze this under the umbrella policy in relation to the CGL policy, showing that property was defined differently between the two, so that's why the umbrella policy applied?
The reason the umbrella policy applied was because the Court of Appeals determined that the contractual liability exclusion in the CGL policy operated to bar coverage. And there's absolutely nothing wrong if a Court of Appeals looks to an exclusion and determines that that is outcome determinative. Many of the cases we see in this area look at the business risk exclusions and don't necessarily definitively address the property damage and occurrence requirement. The umbrella policy did not have a contractual liability exclusion, and therefore the Court of Appeals did the traditional analysis under the umbrella policy of examining the property damage element, the occurrence element, the your product exclusion, the impaired property exclusion, and the your work exclusion. And having done that, the Court of Appeals said this presents a covered claim under the policy.
Thanks for clarifying.
So the faulty construction performance cases are highly distinguishable from product defect cases under Ohio insurance law and the fortuity doctrine. Ohio law and the policy distinguish between an insured's work and an insured's product. The your work exclusion commonly applies in construction cases. The your product exclusion commonly applies in product cases. Although both were included in the policy and raised by motorists, the Court of Appeals found both of these exclusions to be patently inapplicable and properly so.
Thank you, Mr. Dunn. You've used your time.
Thank you, Your Honor.
Okay. Mr. Evans?
Thank you, Your Honor. Yes, the integrated system rule is already utilized by Ohio courts in the context of the economic loss rule. The Wisconsin Supreme Court applied that same principle in the context of insurance coverage. We believe that the opinion from the Wisconsin Supreme Court is well reasoned. It applies, and more importantly, that its ruling is consistent with what the Ohio Supreme Court ruled in the Custom Agra and Ohio Northern cases. There's not in Custom Agra, the Ohio Supreme Court had looked at the purpose and the coverages that were generally provided by CGL policies, and were very clear that coverage is for damage to other property, not to one's own product or one's own work. We believe that the Wisconsin Pharmacal opinion was well reasoned and should be adopted.
How do you deal with the broader definition of occurrence here than in the CGL policies?
Well, there's no question that there's a broader definition under the umbrella policy, but it has that language, neither expected nor intended, from the standpoint of the insured, which is the definition of accidental. So in other words,
well, but occurrence doesn't have to be an occurrence. It's not limited to accidents here. It says events, happens, right? I mean, that seems to change the analysis.
It says accidents or happenings or events which are neither expected nor intended from the standpoint of the insured, which that's the very definition of accidental. So, we believe that the fortuity concept was preserved by definition.
And I went back and looked at your brief. I can't find where you raised that as far as the umbrella policy in the Court of Appeals.
Oh, in the Court of Appeals?
Yeah, I can't. Maybe I'm missing.
Your Honor, I can't tell you if we did or did not specifically. I mean, the Court of Appeals wrote its opinion and made certain findings, and in our view, they went further astray than they should have and did not perform a proper coverage analysis, and then we had to react to that on the appeal in the Supreme Court. But regardless, there's still the issue of whether or not there was damage to other property, which is the second part of the test. That definitely was briefed, and that's a major issue here. And we believe under the integrated system rule that there would be no damage to other property, similar to how that concept is utilized for purposes of the economic loss rule.
Thank you, Mr. Evans.
Okay, thank you.
Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Marshall, we call a 10-minute recess.
The court will now take a 10-minute recess.
Richard Barbera for the respondent, Mr. Mitchell.
Good morning.
Proceed, Mr. Mitchell.
I'm sorry, the first part of that got cut off. Excuse me.
Proceed.
Good morning, Chief Justice O'Connor, Justices of the Court, and opposing counsel, Mr. Bessler. May it please the Court, my name is Ian Mitchell. I'm counsel for the respondent in this matter, Richard Barbera. It's a pleasure to be before you this morning, albeit virtually. With the Court's permission, I ask to reserve 2 minutes of my time for rebuttal.
Proceed.
As the briefing indicates, the respondent, Mr. Barbera, has stipulated to the majority of the rule violations in this case, but respectfully objects to only 2 findings from the Board of Professional Conduct's report of findings of fact, conclusions of law, and recommendation in this case. Specifically, Mr. Barbera objects to the report on the following grounds. First, a violation of the Ohio Rule of Professional Conduct 1.4A4 was not established by clear and convincing evidence at the panel hearing. Therefore, the board's conclusion that Mr. Barbera committed such a disciplinary rule violation should be rejected. And second, under the circumstances of this case, the board's recommended sanction of an 18-month suspension with 12 months stayed is excessive, and instead a 1-year suspension fully stayed with conditions is more consistent with the court's precedent. First, the Board of Professional Conduct's conclusion that Mr. Barbera committed a violation of Rule 1.4A4 should be rejected because the evidence submitted to the board does not establish such a violation by clear and convincing evidence. Pursuant to Ohio law, it is well established that the relator in an attorney disciplinary hearing bears the burden of proving by clear and convincing evidence the facts necessary to establish a violation of a disciplinary rule. As the court is aware, the clear and convincing standard requires more than just a mere preponderance of the evidence, and which will produce in the mind of the trier of facts a firm belief or conviction as to the facts sought to be established. That's through the Disciplinary Counsel versus Squire case, 2011, Ohio 5578. In other words, a more than likely than not standard is not appropriate for a disciplinary proceeding, and significantly more is required.
Counsel, is there controverted evidence, testimony regarding that violation?
Yes, there is, Chief Justice O'Connor. Contrary to the representations made in the relator's answer to objections, and in fact, the comments and findings of fact section in the board's report and recommendation, there was contrary testimony provided at the panel hearing by Mr. Barbera. Although the board's report discussed the finding of Rule 1.4A4 at paragraphs 33 and 34 of its report, there were no citations to any portion of the record, whether it was testimony submitted, exhibits, or other transcript testimony. However, when Mr. Barbera was asked, specifically, which can be found at page 132 of the transcript, do you recall any specific instances where you missed a meeting or an appointment with Ms. Zanglin? He responded, no, definitely not. There is a line that,
counsel, the question is, do you recall? It's not did you, do you recall?
Correct, Chief Justice O'Connor. The question was, did he recall? And he could not identify any specific instances of any meeting that he had missed. And again, contention is that the burden of proof here is on the relator to show by clear and convincing evidence. And in the absence of resolute testimony from Mr. Barbera that would corroborate that, or the documentary evidence that Ms. Zanglin indicated that she potentially had but had not produced for the panel hearing, we contend, Chief Justice, that the clear and convincing evidence standard has not been met in this case for a 1.484 violation. So again, it is our contention the relator cannot sufficiently establish the 1.484 violation merely through her testimony alone, particularly where Mr. Barbera gave testimony that we believe is contrary. He was asked several times during the panel hearing in several different ways, despite multiple objections about the phrasing of the questions, whether he had missed any meetings, and the response was consistent almost the entire way through, up until the end where, again, when finally pressed, he said he could not dispute it. But, our contention Chief Justice, is that the reason that he can't contest it is because the evidence that would otherwise establish it had not been provided at the trial. He was unable to dispute Ms. Anglin's testimony, which indicated that she was not certain which dates had been missed. She could not identify any specific dates at when she had placed a phone call or an email or a text message or otherwise scheduled a meeting with Mr. Barbera. And as a result, Mr. Barbera was unable to hit a moving target, in other words. We understand that the relator would like to single out that one line of testimony where he ultimately indicated he could not dispute it, but that line is again followed by multiple instances where he said he had no recollection of any specific meeting that had been missed. And again, the burden of proof in this disciplinary rule hearing is on the relator to establish that affirmative evidence. And we submit, Chief Justice, that a 1.4A4 violation cannot simply be shown.
Don't we defer to the credibility determination of the board, and the board concluded, or the panel, when we heard the case, concluded that she was telling the truth. So
that's true, Justice DeWine. Typically, when you're dealing with issues of fact, where there's disagreement on the facts of the matter, the board's determination can be deferred to. In this particular instance, Justice DeWine, we would simply call attention to the transcript testimony of Mrs. Anglin, who indicated that she had not turned over any records of these meetings and had not produced any.
But ultimately, it was up to the board to decide whether she was telling the truth. The panel decided she was. That would seem, we have to credit that factual determination. That would seem to me, if you credit that, then the standards seem to be met, isn't it? I've never ever heard a clear and convincing standard say, well, it's not met if there's conflicting testimony.
Justice DeWine, I would respectfully submit that when two individuals, witnesses in a case, submit inconsistent testimony, and when a board makes a determination that one is more credible than the other, that is more akin to a preponderance of the evidence standard, suggesting that it's more likely than not.
Do you have any authority from any place that says that on appellate review that if there's disputed testimony that doesn't meet a clear and convincing standard?
No, Justice DeWine, I do not. Just simply the case law that I cited earlier, that in order to meet that clear and convincing standard, it has to establish that relatively high bar of establishing in the mind of the trier of fact a resolute understanding of what the evidence should be.
But Mr. Mitchell, the board can make credibility determinations, correct?
It can, Justice Brunner, it absolutely can. But with respect to the evidence necessary to establish a 1.4A4 violation, we just respectfully submit that despite the fact that the board may have determined that her testimony was credible, there was in fact contrary testimony and contrary evidence, and also a vacuum of evidence that could have been provided either through the hearing process or in the lead up to it, that would have provided Mr. Barbera the opportunity to respond to the specific allegations of missed meetings or missed emails. But no date was ever provided, and again, no missed emails were ever indicated. As a consequence, it was virtually impossible for him to—
Counsel, did your client not show up in court for his client?
That is correct, Chief Justice O'Connor. We did stipulate that Mr. Barbera missed hearings. Two of them were missed by Ms. Zanglin as well. And the testimony provided by both of them was that they never received notice of those two hearings. But it is correct that we did stipulate that those hearings were missed.
Right. He had notice of hearings and he failed to show, and he failed to notify his client that he was not going to be there.
Those are stipulated violations. That's correct, Chief Justice O'Connor.
And the client ended up 10 days in jail, correct?
That is correct, Justice Fisher. That is not disputed. The stipulations of fact indicate that she was in fact put in jail.
The board report argues that Engel was the correct parallel case. Why do you dispute that?
Well, respectfully, Justice Fisher, the board report doesn't say that Engel is the correct analogy for this case. In fact, it.
Their brief. I'm sorry, it's their brief.
I'm sorry, say that again, Justice Fisher.
It was in their brief. It might not have been in the report, but that's their argument. Engel is the correct parallel case.
That's correct, Justice Fisher. The relator does argue that the Engel case is more analogous than the McCrae case cited in our objections. And as I was saying, the board specifically rejected the application of Engel, indicating for a couple different reasons the facts were just simply, not analogous enough. In particular, Attorney Engel had multiple previous disciplinary violations. The first one that had resulted in a public reprimand. The second one, which had resulted in a significant suspension of 2 years with only 6 months stayed. And considering much of the intentional conduct involved and the rules violations involved in the Engel case, the board, I believe correctly, disregarded that case as providing an appropriate pathway for a sanction in this case.
Well, counsel, isn't it also because Engel did not have a professional conduct rule 3.1 violation, and your client does?
Chief Justice O'Connor, that is almost correct. In fact, where the board referenced the 3.1 violation was with respect to the McCrae case. The Engel case was the more significantly egregious case that the board decided to reject with the 2-year suspension.
Counsel, forgive me, but I'm reading from paragraph 53. The case involves many of the same rule violations and similar aggravating and mitigating circumstances as in this case, although Engel had 2 prior disciplinary offenses and a contributing mental illness. The present case, your client's case, however, involves a violation of professional rule conduct, rule 3.1 that was absent in Engel. Is that not right?
That is what it reads, Chief Justice O'Connor. But as the report reads on, he goes on further. However, we also find that in paragraph 56, we also find that the situations of this case are sufficiently dissimilar from Engel, Roseman, and Walden. And in 58, in the middle of the series, it says that this case, meaning Mr. Barbera's case, involved only the second disciplinary case for the attorney involved, as opposed to Engel, which was multiple. The 3.1 violation.
And in Engel,
excuse me.
In Engel, there was no harm to a client, though, correct? As an aggravating circumstance, I didn't find one.
I believe in the, trying to recall, there's the 2004 disciplinary violation. Are you referring to that, or the 2018 decision that considered Engel's conduct after the fact?
18.
In the third case?
I didn't see any resulting harm to a client.
Well, certainly it wouldn't be to the extent that there was a term of prison like there would be in this case. But again, the board's report references Rule 3.1 with respect primarily to the McCrae case, getting back to Chief Justice O'Connor's point. The board started off with that comparison and indicated that the McCrae case was virtually on all fours and would seem to be, at first blush, I believe it said, a reasonable benchmark for assessing the sanction in this case. The difference that the board pointed out was the absence of a 3.1 violation. However, the distinguishing factor that I would respectfully disagree with the board that was different and of significantly greater magnitude in the McCrae case was the sheer number of violations. The attorney involved in the McCrae case had 21 violations of the rules of professional conduct, including harm to multiple clients. I believe there were 7 clients overall affected, 6 of whom were in similar domestic relations type cases, child support hearings, as with the case at present involving Mr. Barbera.
Counsel, according to the McCrae, the reference to McCrae in paragraph 46, at first blush, it would appear that this case is a reasonable benchmark since many of the same violations are to play. However, there are very important aggravation and mitigation distinctions between McCrae and the present case. McCrae was there was significant mitigation recognized, including a very traumatic personal experience occurring in McCrae's life that is not present in yours. Apparently, her 14-year-old daughter was missing. Your client had nothing going on in his life that we know of that would even compare.
That's correct, Chief Justice O'Connor. There was no mitigating circumstance that was similar, such as a teenage daughter being having disappeared. However, again, the distinction that we would draw and respectfully object to the board's disregard of the McCrae case stems from the sheer number of violations and number of clients affected in the McCrae case. And as a consequence, we would respectfully submit that a 1-year suspension fully stayed would be the appropriate sanction.
Your client had a 1-year suspension. It obviously didn't work. He had monitored probation, and that didn't stop him from committing more violations. So why would we think that a fully stayed suspension is going to work this time to keep him from violating?
Justice DeWine, thank you for the question, Justice DeWine. The attorney involved in the McCrae case also had previous disciplinary history and had a similar suspension.
Okay, but address your client. Well, why? I mean, he just got done doing probation, and the state suspension didn't stop him from violating the disciplinary rules. Why would we think another state suspension won't make any difference?
Justice DeWine, Mr. Barbera has indicated that he is regretful as to how the Zanglin case was handled. There were a culmination of different circumstances in the Medina County Domestic Relations Court that to a certain extent made it difficult for him to get to those hearings, as Ms. Zanglin agreed. And we would just respectfully submit that Mr. Barbera, through his community involvement and the letters of recommendation and support, indicate what kind of individual he is and that he is capable of improving his conduct as an attorney. I see that my time is nearly up.
Thank you. Mr. Bessler. You'll have to unmute yourself.
May it please the court, Chief Justice O'Connor, distinguished members of this court. My name is Adam Bessler and I represent the Office of Disciplinary Counsel. Respondent, who has been previously disciplined, failed to appear in court on 3 separate occasions. His client, Diana Zanglin, not only lost her day in court, but spent 10 days in jail in her child support modification case. I'd like to discuss 2 points this morning. First, that an 18-month suspension with 12-month stay is the appropriate sanction. And second, that relator did prove by clear and convincing evidence that there were 3 separate violations of Rule 1.484. Turning to my first point, an 18-month suspension with 12-month stay is the appropriate sanction because disciplinary counsel versus Engels is the most analogous case law, and disciplinary counsel versus McCrae can be distinguished for 3 reasons. Disciplinary counsel v. McCrae can be distinguished because, first of all, the McCrae case takes place during a finite period of time, which, as this court has already pointed out, is when Attorney McCrae's teenage daughter is missing. And I think everyone understands the sort of intense stress and anxiety an attorney would be under, or any parent would be under, when their child is missing. Juxtaposed with that, in the present case, as the court has pointed out, a respondent has not given us any indication what was going on in his life over this 2-year time span that would be in any way comparable to what Attorney McCrae was facing. He has taken limited responsibility in this case. He has stipulated to some matters and admitted to some of the violations, but he's also pointed some of the blame at his client and pointed some of the blame at the clerk of courts. We would submit he's not fully taking responsibility, and that's problematic, especially given that he's been previously disciplined. The second distinguishing factor in the McCrae case is the amount of harm to the client and the mitigation of that harm. In the McCrae case, Attorney McCrae certainly does neglect several matters, but once she realizes she's neglecting those matters, she realizes she needs to take a step back. She asks local judges to transfer her cases to other attorneys, and ultimately she takes a step back from the practice of law. In the respondent's present case, after he misses those first 2 hearings, the initial hearing in the summer of 2017, where he doesn't file a notice of appearance, 5 weeks after he's been retained. And then after that initially leads to his client's motion to modify child support being dismissed. He files objections to that magistrate's decision, and he misses court again in the summer of 2018 because he'd scheduled a hearing at 1 p.m. in Akron, knowing that there was also a hearing, in this case, at 2 p.m. in Medina. After that initial neglect, Mr. Barbera's response is to file what he admits and is stipulated as a frivolous appeal to the 9th District Court of Appeals. He doesn't brief that appeal. It's dismissed for failure to prosecute. He doesn't notify his client of that dismissal, which directly leads to her relying on his representation that the underlying case in Medina County will be stayed for an extended period of time. She's not expecting the purge hearing when it's set in 2019. Mr. Barbera admits he doesn't check the docket after he learns that the case is dismissed in the 9th District. And this neglect is what leads to her spending 10 days in jail. So not only is there significant harm to the client, which distinguishes it from McRae. The third point that would distinguish this from McRae is the prior discipline. While Attorney McRae does have prior discipline, it's based on a CLE, failing to meet CLE requirements and failing to complete her biennial registration. This is administrative in nature, and it actually occurs in time after the earlier neglect. And it's all during that same period of time where her daughter's missing and she stepped back from the practice of law to focus on her family. Alternatively, in Mr. Barbera's case, as the courts pointed out, he was still under his previous suspension when some of this initial misconduct occurs. His prior discipline not only includes an IOLTA issue, but it involves a failure to cooperate, which we also see here. This is his second time in a disciplinary case failing to cooperate. Turning to the Angles case, relator submits it is the most analogous for several reasons. In the Angles case, we have only one client. It's a debt relief action. And the attorney Angles, he fails to not only pursue the debt relief action, but to communicate with his client. And the client ultimately has to resolve it herself pro se. In Angles, we see the same aggravating factors, except in Barbera's case, he has one additional aggravating factor, which is the harm to the client. In Angles, we see Attorney Angles had two more mitigating factors. Significantly, he had a mental health issue, which helped explain his neglect. And here in Mr. Barbera's case, there's no explanation for the neglect. We also see almost identical rule violations in the Angles case, except here in Mr. Barbera's case, there's an additional 3.1 violation, as has been pointed out this morning. So in summary, the Angles case has fewer aggravating factors, more mitigating factors, and the Angles case has fewer rule violations. While Mr. Angles does have two instances of prior discipline as opposed to Ms. Barbera's one, the court has weighed that, I believe, appropriately by not only looking at the more increased severity in Mr. Barbera's case, but also the downward was given an 18-month suspension with 12 months stay. Turning to my second point, relator has proven by clear and convincing evidence that there were 3 violations of Rule 1.4A4. Those violations were 1, missing meetings with his client and failing to inform his client he would not be at those meetings. 2, ignoring phone calls and text messages from his client. And 3, failing to inform his client that the 9th District Court of Appeals case had been dismissed. Addressing those in reversed order, stipulation 21 for Mr. Barbera is that he did not inform his client that the 9th District Court of Appeals case was dismissed. Based on this stipulation and the fact that it's corroborated through the witness's testimony, both Ms. Zanglin and Mr. Barbera at the hearing, relator submits that this is an undisputed violation of Rule 1.4A4, proven by clear and convincing evidence. It's not been addressed at all in respondent's objections, and we believe that this alone is sufficient for the board's finding of a Rule 1.4A4 violation. Second, there was testimony from Ms. Zanglin. There was live sworn testimony from a witness that at 5 separate occasions, Ms. Zanglin had scheduled hearings with Mr. Barbera. She traveled from outside the county to be at those meetings with Mr. Barbera, and he failed to appear at those meetings and failed to let her know he would not be there. As we've quoted in our brief, Mr. Barbera states he can't remember one way or the other what happened, but ultimately admits that he's not going to dispute Ms. Zanglin's testimony. And the board found Ms. Zanglin ultimately to be credible at her hearing, and specifically stated in the board report. Relator submits that because we have sworn testimony, which is undisputed. This is clear and convincing evidence that meetings were missed, and notification was not given to the client that that Mr. Barbera would not be at those meetings. And the third point, the third violation of Rule 1.4A4 was the ignored phone calls and text messages. As the testimony from the transcript shows, this occurs around the time frame where the purge hearing is missed. It's around February 20th when Ms. Englund learns that she has missed the purge hearing and the court's ordered her to be arrested and spend 10 days in jail. But as Mr. Barbera admits in the transcript and Ms. Englund testifies, it's not until around March 7th that Mr. Barbera actually speaks with Ms. Englund. So there's approximately a 3-week time period there where Ms. Englund is trying to get a hold of her attorney and find out how this purge hearing was missed and what to do about this 10 days in jail. And as Ms. Englund testified at the hearing, she reaches a point where she is doing online research, looking to find out if there's an obituary for Mr. Barbera because she doesn't know if he's alive or dead. It's so difficult to get a hold of him. For these reasons, Relator submits that there are 3 clear violations of Rule 1.4A4, all proven by clear and convincing evidence.
Counsel, I have a question for you, and that's the fact that apparently Ms. Englund had documentation in the form of texts and letters and phone records. Why was that not asked for by the disciplinary counsel?
Yes, Chief Justice. As part of our investigation, Relator was deposed, or I'm sorry, Respondent was deposed by Relator, and his testimony at the deposition was the same as his testimony at the hearing, that he was not going to dispute his client's testimony, that he missed meetings and he failed to return text messages and phone calls. Based on his testimony at the deposition that he was not going to dispute those allegations, Relator believed it to be duplicative to obtain more phone records. And ultimately, Mr. Barbera has the same phone records, same access to phone records really as he would be able to obtain from Ms. Englund. These are phone calls and text messages between the two, attorney and client. And he was perfectly capable of looking at his own phone records and introducing that as evidence to dispute this allegation. That was something he wanted to do and chose not to.
Counsel, would you do it differently now, knowing where we are today?
Yes, if I had known that this was going to be disputed, I would have made some changes. Nonetheless, though, Chief Justice, Mr. Barbera has stated that he doesn't dispute missing these meetings, and there is sworn testimony. We believe we've met our burden of providing clear and convincing evidence. In conclusion, for the second time in 3 years, Respondent has engaged in misconduct, this time while under suspension, and he's failed to cooperate for a second time. Worst of all, his misconduct led to his client spending 10 days in jail. Relator asks that the court overrule Respondent's objections, suspend Respondent for 18 months with 12 months stayed on the condition that he makes $900 in restitution to Ms. Englund and he refrains from future misconduct. Thank you.
Counsel, one question. In the first Barbera case, was there a lack of cooperation aggravating factor as in here?
Yes, Your Honor.
Thank you.
Mr. Bessler?
Yes, Your Honor.
The fact finder on the board, I asked Mr. Mitchell about it determining witness credibility, but it also can weigh the evidence in reaching a conclusion by clear and convincing evidence, correct?
I'm sorry?
It can weigh the evidence in addition to determine credibility in order to reach its conclusion by clear and convincing evidence, correct?
Yes, Your Honor. The board can weigh the evidence as they see fit and reach the conclusion that there's clear and convincing evidence.
Thank you.
Thank you.
Thank you.
Mr. Mitchell. You'd have to unmute, sir. You've used your time. You may take a minute.
I'll simply say, Chief Justice O'Connor, that Mr. Barbera appreciates the court's consideration of his objections to the board report and respectfully submits that a Rule 1.4A4 violation was not shown by clear and convincing evidence, and that the appropriate sanction for this case, misconduct, can be derived from the McRae case in this court's precedent from recent history. Thank you.
Thank you, Mr. Mitchell. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Marshall, will you adjourn the court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.